my faith arising. I'm crawling out the trenches, holding me.
Hello visionaries, welcome back to my channel. My name is Maresa Talbert. I'm the founder and CEO of Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I've been promising you all a video explaining the differences and the duties of directors and officers of a corporation, and that goes for nonprofit corporations for that matter. If you haven't realized that your nonprofit organization is a not-for-profit corporation, let me know in the comments. Anyway, that's a bigger issue for a different video. I have many clients who either start their for-profit or their not-for-profit corporation and really have a hard time distinguishing between the roles of the officers and the directors. In my C Corp video, I mentioned that directors elect and oversee officers, and the officers manage the day-to-day operations of the corporation. These executives are generally recognized by having the word officer in their title, such as your CEO, your Chief Executive Officer, or your COO, your Chief Operating Officer, or even your CIO and your CMO, your Chief Information and your Chief Marketing Officers. You get the point. But I want to dive further into the roles of these directors and officers, and more importantly, their responsibilities to a for-profit or not-for-profit corporation. You know the drill. Let's jump right into it. So first, let's talk about the directors. To distinguish among the directors, we're going to call them directors of the board, hence the title Board of Directors. Directors, again, manage the business of the for-profit or not-for-profit corporation. And this happens when they set policy, as they supervise officers, as they declare distributions, as they determine when the stock will be issued, and when they recommend fundamental corporate changes to either shareholders, investors, or stakeholders. On the other hand, we have the officers, and we will distinguish them as officers of the corporation. Officers may serve on the board of directors or can be elected from the board of directors, but it doesn't have to be either. Officers are selected and removed by the board of directors. And they're also considered agents of the corporation, so they have the authority to bind the corporation by their actions. Binding basically means that officers have the authority to enter into contracts and enter into transactions on behalf of the corporation for which the corporation will be held liable. So, for example, if the president of a corporation enters into a contract with another corporation, that corporation can reasonably rely on the fact that because this person is the president of the corporation, they have the authority to say yes to this transaction. Traditionally, a for-profit corporation may have some of those CEO and COO titles, but by law, both a for-profit and not-for-profit corporation are required to have a treasurer, a secretary, and a president. A corporation may have other officer roles like a vice president, but it's not required by law. In a for-profit corporation, one person can hold all the titles, president, secretary, and treasurer, at the same time. In a not-for-profit corporation, generally a president cannot be either the secretary or the treasurer at the same time. However, the secretary and the treasurer can be the same person. So, in a not-for-profit corporation, you need at least two people to start a not-for-profit corporation. You need someone who's going to serve as your president and someone who will serve as your secretary and treasurer. But of course, all three of those roles can be held by three different people. Additionally, directors are generally not employed by the corporation and usually cannot be paid just for being a director, whereas officers are generally employed by the corporation and get paid very handsomely to be an officer. And that applies to both for-profit and not-for-profit corporations. Yes, nonprofits, you can pay your officers. Okay, so now that we've distinguished between what an officer is and what a director is, let's talk about the responsibilities and duties they owe to the corporation. Both directors and officers are fiduciaries, and they owe fiduciary duties to the corporation. Simply put, a fiduciary duty is a commitment to act in the best interest of a person or an entity, and in this case, that entity is the corporation. So there are two primary duties that are owed by both directors and officers. They are the duty of loyalty and the duty of care. So let's break down the duty of loyalty. The duty of loyalty prohibits directors and officers from acting in their own self-interest or from receiving an unfair benefit that is to the detriment of the corporation or its shareholders. How does this show up? What does this look like? Check out this clip.
Good things are a signature of Martha Stewart living. They're those simple, clever shortcuts and solutions that make everyday living just a little easier.
Known as the most famous homemaker in America, Martha Stewart transformed entertainment in the home into a worldwide media empire. With a daily TV show, her own product line, and countless publications, Stewart became a billionaire when her company went public in 1999. 2 years later, Stewart's star lost some of its shine when she was accused of insider trading.
In New York today, Martha Stewart was indicted on criminal charges relating to an insider trading scandal that began more than a year ago.
When she's convicted of all these charges, she faces up to 30 years in prison and $2 million in fine.
Martha Stewart's close friend, Sam Waxel, was CEO of Imclone, a biotech company that produced anti-cancer drugs. When Waxel learned that the Food and Drug Administration was about to reject Imclone's cancer drug, Erbitux, he called his stockbroker, Peter Bukanovic. Bukanovic was on vacation, so Waxel spoke instead to his assistant, Doug Faneuil, and instructed him to sell Waxel's Imclone stock. Faneuil contacted Bukanovic and explained the situation. Bukanovic, who was also Martha Stewart's broker, told Faneuil to call Stewart and tell her that Imclone's share price was likely to drop because Waxel was cashing out. Faneuil did so, and Stewart sold all her Imclone shares 1 day before the announcement of the FDA's rejection. As expected, when the news became public, Imclone shares declined sharply. Had Stewart not sold, she would have lost almost $46,000. Were Martha Stewart's actions ethically wrong?
So depending on how old you are, you may or may not be familiar with Martha Stewart. If you are my age or older, you'd probably remember her as this big business mogul. If you are younger than me, and I'm not going to give away my age too much, you might know her from, her affiliation with Snoop Dogg. Anyway, the point is, back in the day, Martha Stewart was sentenced to 5 months in prison for insider trading, which is a form of self-dealing. She received some insider information, sold some bad stock, and saved $45,000 because she sold the stock a day before it was set to plummet in the stock market. Now, I don't know if Martha Stewart was an officer or a director of the corporation that she owned stock in at that time, but this is just an example of how a director or an officer could engage in self-dealing. Another example of how the duty of loyalty shows up is if there is an opportunity for a director or an officer to compete with the corporation. For example, let's say Sharon is a director at Home Depot. It would probably look bad for her to also be an officer or a director at Lowe's because they're competing companies. And how is she going to make decisions in the best interest of either when she's serving two competing companies? Lastly, the duty of loyalty can be tested when there is an opportunity that is available to either the corporation and or an officer or a director. For example, let's just say Jackson is the CEO of My Realty Corp, and they develop condo projects. And Jackson learns about some land that has been zoned for condos. Can Jackson buy that land for himself as an investment? Well, the answer is no, because That type of investment is in the corporation's line of business. So if Jackson wants to get in on that opportunity, he must, number one, first tell the board of directors about the opportunity. And two, he must wait for the board to reject the opportunity. Is this making sense? Okay, so now let's talk about the duty of care. This duty requires both the officers and the directors to act in good faith and to make decisions with a reasonable belief that their decision is in the corporation's best interest. So, how can a director or an officer breach this duty? Number one, by doing nothing, such as failing to attend meetings, failing to stay engaged with the business of the company, because a reasonable person would at least attend some meetings and at least stay engaged if they wanted to actually be a director or an officer of the corporation. And number two, the other way that the duty of care is breached is by a director or an officer doing some type of action that actually hurts the corporation. Now, there's hope. The good thing is, directors and officers are not held liable in all instances of making a bad decision for a corporation. There is a doctrine called the business judgment rule. And the business judgment rule says, if the directors and officers make a decision on behalf of the corporation and that decision turns out to be a bad decision, they may be justified if they have these four things. Number one, the decision was an informed one. Number two, the decision was made in good faith. Number three, the decision was made without conflicts of interest. And number four, the decision was rational. So if directors and officers can show that there was some due diligence put into making a decision, then generally they will not be held liable for that decision, even if it hurts the corporation, even if the shareholders lose money, even if something bad happens. So let's apply this test. This test could be applied to the current allegations against the Black Lives Matter organization. There are allegations that one of the founders hired her family members and specifically paid her child's father more than $1 million to provide security services for the organization. Could that decision meet the business judgment rule? Without any further information, let's measure that up against the factors. Number one is informed. Depending on the scope of services, it may be likely that there are a number of other security companies that could provide the same or similar scope of service for far less than $1 million. The board of directors would need to show that they did this research and compared different security companies, compared their services, and in the best interest of the company decided to go with this person because of XYZ reason. Number two, made in good faith, which basically means free of self-interest and in the best interest of the corporation. We would need to look at all the facts, but it could be fairly difficult to argue that such a decision was made in the best interest of the corporation. Number three, without conflicts of interest. That's pretty self-explanatory. Clearly, using the example that I gave, there would be a conflict of interest if the founder of the organization and the owner of services being provided to the organization are related. And number four, with a rational basis, which is asking, would a reasonable person also make the same decision? And that's up for you to decide. So that is how we apply the business judgment rule. Of course, a determination of breach and liability must be decided knowing all of the facts and on a case-by-case basis. Lastly, I will mention the duty to disclose. Directors and officers also have a duty to disclose important information to the corporation, to the other members of the board. And as we've talked about, these kind of disclosures include conflicts of interest, corporate opportunities, and the like. And while this is not an all-inclusive discussion about the roles and responsibilities for officers and directors, this gives you a high-level overview for-profit and not-for-profit corporations. Well, that's all I have for this video. Let me know in the comments if you have a question. Make sure to give this video a thumbs up. And as always, this is Talbert Law Office, your favorite go-to legal resource for all things business, nonprofit, and intellectual property law. I'll see you in the next video.
I done made it this far. I'ma keep it pushing, yeah. Even made it through the